Good evening. Welcome in daily UPSC editorial audio program. Legislative decline the Hindu. Denial of legislative debate for the democratic backsliding in India. A blow for the right of legislative in lawmaking. Now the full editorial. Legislative decline the Hindu. Denial of legislative debate for the democratic backsliding in India. Editorial. Both the security breach in Parliament last week featuring a theoretical a theatrical attempt by individual to highlight an issue of public importance, unemployment, and the union government's response have been deeply problematic. Problematic. The government's stemming of any debate over this issue in Parliament and the chair's recourse of an unprecedented high number of suspension of opposition legislators following their demand for a statement in the House and a debate have been in line with its disregard for deliberative democracy. As many as 78 opposition members of parliament were suspended on Monday. 14 more were suspended earlier, 92 in total, and nearly matching the 94 suspensions overall since 2014 prior to this session. Unlike in the two Lok Sabhas 2004 to 14, when even ruling party legislatures, including rebels, were suspended for unruliness. Only opposition members have been subject to suspension, which includes those for far less severe offences since 2014. The hallmark of a functioning democracy is deliberation, wherein elected legislatures debate and discuss issues of public import and seek solutions to issue that affect citizens. A thorough deliberation involves not just televised speech from parliament but also debates, the utilization of parliamentary and standing committee to delve into the issue and for bills and legislation to be discussed threadbare before consideration. Instead, over the course of recent parliamentary sessions during the National Democratic uh, Alliance tenure, there have been multiple attempts at uh, brobating the opposition, getting bill, bills passed without adequate discussion, disallowing amendments on merit, and underutilization standing and parliamentary committees while trying hard to play to the gallery. Legislative businesses and per harmony work have been given short shift while uh, the- theatrics by legislature in both the treasury and opposition benches and one upmanship through the use of suspensions have dominated proceedings. It is no wonder that such actions have compelled global democracy reports by research institutions such as VDEM, uh, VDEM Institute to characterize India's democracy as an electoral or autocracy. Worse, the use of draconian unlawful activities prevention act to innately target dissenters such as the who threw cons- uh, protesters who threw uh, canisters and raised slogans in parliament last week, who also had also fallen into the recent pattern of a deliberate e- equation of dissent with terror. Again, this has led the US-based Freedom House, the measure civil and political liberties, to declare India as partially free. The recent actions by the government only contribute further to the backsliding of democracy in India, making these developments a matter of serious concern. A blow for the right of the legislature in lawmaking. PDT Achari is former General Secretary General Lok Sabha in a landmark judgment delivered on November 10, 2023 in the state of Punjab, also Principal Secretary to the Government of Punjab and another. The Chief Justice of India, CGI DY Chanchud, gave a creative interpretation to Article 200 of the Constitution of India, which reveals to the options before a governor when a bill, after being passed by the state legislature, is presented to him for his assent. The new interpretation relates to the real meaning of the first proviso to Article 200, which says that the governor may send the bill back to the assembly with a request for reconsideration of the bill as a whole or certain provisions thereof. It further says that if the assembly after such reconsideration passes the bill with or without the amendments, the governor shall not withhold assent from the bill. There has been a considerable amount of confusion about the meaning of Article 200 and its proviso. Most of the comment, commentators of the constitution like D.D. Basu and others have held the view that the governor's power to withhold assent under this article has a finality about it, and once assent is withheld, the bill dies a natural death. They were also the view that the option of sending the bill back to the assembly for reconsideration under the first proviso is discretionary and not mandatory. Thus, there was a presumption that the governor's power to withhold assent from a bill is absolute. Emphatic in saying no delay, but the CGI by linking the withholding of assent with the sending of the bill back to the assembly for reconsideration has virtually knocked out the option of withholding assent. The judgment says that the governor decides to withhold assent has to send it back to the assembly immediately for reconsideration. In which case he has no other option except for give assent. Needless to say that through his judgment, the CGI in a far-sighted approach has protected the rights of the legislature in the matter of lawmaking, and in fact the entire constitutional system for the uh, depre, uh, depredations of unelected governors. Nevertheless, the woes of state governments are not over yet. It has been common practice by some governors not to take any decision on the bills sent to them for assent. They have been sitting on bills for 2 or 3 years, virtually negating the legislative exercises of the state. The Supreme Court of India has in the Punjab case said emphatically that governors cannot delay the decisions on the bills. Thus, the decision of the top courts has brought greater clarity to Article 200, and governors will have to quickly take a decision on the bill on bills on bills for the president's consideration. But there is still an area which can be exploited by the governors to frustrate the lawmaking exercise of state governments. Reserving a bill for the consideration of the president is an absolute option still available to a governor. The crucial question is on what kind of bills a governor can send to the president for his consideration. The second proviso to Article 200 mentions one kind of bills which are mandatorily to be reserved for the consideration of the president. There are bills which derogate from the powers of the High Court in such a way as to endanger the constitutionally designed position of that court. So the constitution required the governor to send all such bills for the consideration of the president. Since consideration by the president means consideration by the union government, the official of the home ministry will in effect decide the fate of such bills. The constitution, in fact, does not refer to any category of bills apart from the bills mentioned above, which can be sent to the president for his assent. Therefore, taking a surface view that governors can use his discretion to send any bill to the president. In fact, that is precisely what the governor of Kerala, Arif Muhammad Khan, did the other day. He did not act on 8 bills that were with him for over 2 years. When the Supreme Court took up the Kerala's government petition challenging the governor's inaction, he gave his assent to one bill and sent the 7 bills to the president for his consideration. The court is a court, it is learned, is going to examine this issue, namely what bills can be reserved for the consideration of the president. The Tamil Nadu government's governor sent 10 bills for reconsideration by the assembly after many complaints by the state government. The assembly, after reconsideration, sent the bills to the governor without accepting any amendments. But in the strange act of the governor sent all those bills to the president for his consideration, which is plainly against the constitution. Article 200 first proviso require him to give his assent to the bills. So the question of crucial importance in the present political context is whether a governor can reserve bill for the consideration of the president at his discretion. The Constitution is silent on this. It makes only an indirect reference to the reserving of wills for the consideration of the President in two places. Article 213 deals with the ordinance making power of governors. Under this provision, in certain cases, governors can promulgate an or ordinance only by instruction from the president. Under clause B of the above article, the governor can promulgate an ordinance only with instructions from the president in a case where he would have deemed it necessary to reserve a bill containing the same provision as in the ordinance. The word deemed it necessary indicate the making of judgment by the governor in terms of the constitutional scheme of the power of legislative division. In other words, the governor cannot act on his whims while deeming it necessary to reserve the bill issue of state subject. The second place where the constitution makes an indirect reference to the president's assent to a state bill is in article 254 under clause 2 of this article. A state law on an item in the concurrent list will prevail in that state even when it contains a provision repugnant to the provision of an existing central law if it has been reserved for the consideration of the president and has received his assent. This would mean that the bill on a concurrent subject can be or need to be sent to the president or assent only if it contains provision repugnant to an existing central law. But it does not indicate that every bill on a concurrent subject should be sent to the president for assent. In fact, the president has no jurisdiction to scrutinize and give assent to the bill exclusively on a subject in the state list because of the federal scheme of legislative decision. Therefore, it would seem that if the governor sends a bill on the state's matter to the president, it would be an abdication of the constitutional duty of a governor. So, from the above analysis, it can be concluded that the governor cannot send to the president for assent bill which are exclusively of the state subject. Also, he cannot send bills on concurrent subject if they do not contain provisions repugnant to the central law. If the governor thinks that the bill contains unconstitutional provisions, the only option for him is to send it back to the assembly for reconsideration. A governor is not personally responsible for anything done by the government. Further, constitutional validity of a law is decided by the court, and neither the governor nor the president has any jurisdiction over it. Thank you.